Well, first of all, thank you very much. And thank you everyone for joining me this afternoon. You're very brave. You're joining us on the legal topic of contractual relationships, which I thought might scare people to death, but it's really quite nice to see many faces because let's face it, these things are actually unavoidable, and understanding them is really quite important. Today, I'm going to make this presentation together with Jonathan Moore, as Kevin had already explained. So the way we're hoping this will work is that I'll primarily present the content, but please feel free to ask questions whilst I'm talking. I don't mind that at all. And if it's more interactive, even better. That will give us an opportunity to answer your questions now, and also for Jonathan to chip in and share his expertise. My first slide is a little bit about my background. Then I'm hoping to talk through a diagram of contractual relationships, and then primarily then I'll focus on collateral warranties and a few other pointers today. So really, I qualified as a solicitor a number of years ago, and I was working as a lawyer in the city for about 7 years. My primary sort of background was litigation and contractual disputes, and I also specialized in insurance law. So a lot of my clients were insurance companies, but in essence, I was dealing with sort of commercial disputes. It could be in sort of just general business background or property background. I no longer practice because I am a full-time property developer, whereas Jonathan actually is practicing. He's a solicitor and a partner, so I'm really grateful that he's on the call today, so that between us we can answer any of your questions so that they can fall into sort of our legal expertise. I'm sure both of us will be able to tackle anything you may want to ask us today. So whilst I was working as a solicitor, I already was doing a number of developments, and they tended to be smaller developments, HMOs, sort of buy-to-lets, residential apartments, conversions, that kind of thing. And once I've done 6 or 7 of those and amassed some capital, I decided to jump ship, and I basically quit my beautiful legal job and became a full-time property developer, which enabled me to get onto a larger project. And I primarily now convert commercial type of buildings to residential apartments. That's our primary strategy. I then also became a partner in a group of companies called Dapatchi Group. So I've been a partner within that setup for about 4 years of my sort of 6-year full-time developer career, so to speak. And so this next slide is just really an overview of what we do. Some of you already may know our companies and some of you may not, but basically we've grown our companies to a group of companies. So we have our development side, we have a construction company, we've got our own architecture company, sort of electrical part of it. We've also got a company called Dapatchi React, which is more of a sort of maintenance side of it. We've got contracts where we, let's say, provide an electrical package to Amazon warehouses or Doncaster Airport or, another sort of large landlord. And so in effect, what we offer is a single source solution, because we're already developers, we're consultants, we can deal with drawings, and we can provide that whole package. We still obviously work with other people, we still work with other professionals as well, because we have quite a lot going on. But our core sort of business is actually quite sufficient. I'm moving on now to my next slide. I don't know, am I able, Kevin, to show my sort of mouse at all, I wonder? Hang on.
Might not be, no.
I might have to sort of because it is for this particular slide. Can you see my mouse now?
Yeah, that works.
Okay, I'm just gonna do this for now because it is quite important that I have sort of like a source, to sort of point to things at the moment. Okay, so today what I wanted to talk about is contractual relationships in this sort of like web of a development, because what I find is that a lot of people don't actually understand these relationships. I will delegate some tasks to my team members, and although they're experienced and they've been developing for a number of years, what I find is, a lot of the time, the paperwork that needs to be completed or things to be implemented, they're not done properly. And actually, the true reason is because people, they won't admit it, but they don't actually understand why they're doing it, or, what sort of sits behind it. So really, to some of you, I mean, this will be really obvious, and to some, not so much, or you might find actually that's something that you've been doing, you finally understand why you're doing, and maybe a penny will drop, somewhere, somehow for you. So I'm going to go through this. So today I'm just going to talk about contractual relationships. So I'll start, there is a number of you I can see that fit, many of these boxes. Some of you are developers, some of you, so I've positioned the employer in the middle, which is in essence a developer. Sometimes you can have an employer who's not a developer, for example, someone who wants to develop a group of companies, who may employ a developer, and so the owner of that group of companies will in effect be employer. But for today's purposes, I will call a developer to be in the shoes of employer. So as a developer, you may enter into a number of contracts when you start your development. The primary one, of course, is the building contractor appointment, which is here. And usually you will enter into some sort of building contract, generally a form of what are called JCT contract. And Jonathan had made a very good presentation, I think, a couple of months ago, which was very helpful, which went into a lot of detail about JCT contracts and what they're about and the sort of problems that may arise. Then also you will appoint professional consultants, and these can be anything, architects, your designer consultants, structural engineers. So for example, at the beginning, you may go for like a planning permission type of project, and you may, from the very beginning, before you even employ a building contractor, engage your architect, let's say. And so therefore you will enter into this contract, which I called appointments. You'll appoint your consultant to, let's say, prepare a set of drawings. Then you also, down the line, once you've got your planning permission, let's say, will get a funder on board to get your funding for the project. So you'll have a bank sitting here, and you'll enter into a facility agreement, which will also have, a number of other documents sitting alongside, like mortgage, deed, debenture, etc. So you'll have that contractual relationship there. You may be required to enter into this relationship, which is employer's agent. Some banks prefer you to have an independent employer's agent, and the need for that employer's agent is really to facilitate, for the purposes of the funder, sort of overlook the contract and facilitate the administration of it, in essence, to check that every month the works are undertaken and quantify those works so that the funds can eventually be released. But in essence, it's the developer that appoints that agent, although they are supposed to be independent. They're not supposed to be biased and just do whatever you tell them to do. But in essence, the contractual relationship is between the developer and that agent. Then sometimes it will be the building contractor, once the works had started, who will appoint some of the professional consultants. It could be that if it's a design and build contract, the building contractor will appoint architects at that point, if they haven't been appointed yet, or they will appoint other types of professional consultants, structural engineers, HMVR consultants, you name it, depending on the project. There will be a number of professional consultants there. A building contractor will also appoint a number of subcontractors. You may not always know who they are. I mean, generally, many contracts are subcontracted. You know, the construction industry primarily sort of usually has the managerial sort of employees and then subcontracts the majority of works. You know, and this could be anything. This could be electricians, plumbers, joiners, more specialized subcontractors like roofers, etc. So there's a whole myriad of subcontractors. Then also, once you've developed your development, you may want to sell it. So you will have this agreement of sale between the developer and the buyer, or you may want to retain the development and you may want to lease it. So you will have some tenants and you'll have that agreement for lease. So probably the developer has most of the contracts, as you can see, sitting there in the middle, but with the building contractor probably coming sort of next with facilitating all of this, like this part down below. And really, so what I wanted to point to today is the need for these collateral warranties. Now, these arrows represent an actual contract sitting in place. So primarily, of course, the contract is there to make sure that the parties carry out what they agreed to carry out. So it's really to safeguard both parties' positions and explicitly say that one party will do something for the other party in return of whatever it is they agreed to give in respect of it. And there will be a number of issues that may happen on the development, which may raise who can, in essence, sort of resort to who to solve these issues. So, for example, if we take this upper part here, the developer obviously has a duty under the facility agreement to carry out the development and return the funds. If the developer, for example, goes insolvent or is not carrying out the works in the proper way that the funder is expecting the developer to do, the funder will want to step in here and take over the project or have the ability to do so. And this they already will be allowed to do under the terms of the facility agreement. So the facility agreement will specifically state that the funder may do so. Now, the facility agreement cannot, or it doesn't really allow to suddenly for the funder to go and speak to the building contractor and direct the building contractor to do whatever it wishes to do, because that particular contract simply doesn't contain these clauses. It's between the developer and the funder. So there is no direct relationship, contractual relationship between the funder and the building contractor. And this is where the collateral warranties will come in. Similarly, for example, having appointed the building contractor, if the works are not going well, if they're not being carried out properly, let's say the building contractor had appointed a structural package there, and there is a structural engineer who's either not carrying out works properly, or let's say the development has completed and there are eventually some issues with the development, let's say cracking had appeared in walls, etc. And let's say the contractor is insolvent. If the developer wanted to actually go and explore whether the structural engineer had done anything wrong in respect of that cracking and found out that they did, they don't again have that contractual relationship to say, Mr. Structural Engineer, you had done something wrong, you've breached the contract, because there is no that link. There is no contract between that structural engineer and that developer. So that developer cannot pursue that structural engineer, for example, directly where the contractor had gone insolvent, for example. So generally, the contractual relationship would dictate that the developer from here has to claim against the building contractor if something goes wrong. And then the building contractor would bring in these parties to see if these parties had done something wrong, you know. So anything that happens, if the building contractor is still solvent, then that relationship really helps, because the developer goes after the contractor. So as you can see, there are some problems here, because some of these parties will want to have that additional extra control or ability to pursue some of these key parties, because, you know, these parties, primarily the developer and the funder, have a very keen interest in the building, financial or otherwise. And so this is where the collateral warranties come in. So I'm going to go to the next slide. And really explain what they are. So I've taken one bit of the relationship from my diagram. So as you can see, I've taken as an example the employer, i.e. the developer, who's got the relationship with the building contractor, who'd in turn, let's say, appointed a structural engineer, who now, let's say, had done something wrong and I need to pursue that party. The collateral warranty is put in place, which is in red, to really create that connection to that appointment. You see where I've put appointment. So this contract, the appointment represents the actual contract. Whatever was said in that contract, the developer becomes privy, in essence, to that contract by way of putting in place the collateral. Because the collateral warranty is basically another document, another contract, okay? And that red, the collateral warranty contract, basically will say whatever contractual obligations sit underneath or within that appointment contract, that professional consultant promises to carry out to the developers, if that developer also was party to that original appointment contract. So in essence, it gives the developer the right to pursue, a contractual right to pursue that structural engineer or consultant, whomever it would be, without which it could not. Originally collateral warranties sort of became about really because buyers would buy apartments and something would go wrong, you know, there would be defects within buildings and they could not pursue, let's say, architects or, you know, these third parties where the developer, you know, is no longer in existence, and where there was no contract in existence, they had to pursue it in the tort of law. You'll know the concept of negligence, you know, so where it was established that there was a duty, but they couldn't recover losses because they were regarded, defects were regarded as economic losses. But basically, the crux of the matter was that there was no contract. They tried to pursue third parties, you know, in the tort of in the law of tort, but they couldn't for a number of reasons. It wasn't recoverable, and hence sort of the need for these extra contracts, which are called collateral contracts or warranties. So as I said within my bottom 3 bullet points, basically those collateral warranties warrant that this third party, i.e. for example an architect or structural engineer, carries out their obligations under the original contract, and therefore it provides that contractual right of redress to enable to claim the losses. Okay, so who should be the beneficiaries of these? I'm going to go one slide back and I'm just going to sorry, I'm just going to do it in a simpler way. So I'm going to have to go back so that I can actually point again. So who is, when and where do you need to create this? So initially, the primary parties that really want to have these collateral warranties in place are the developer and the funder. I mean, by the time you actually put funding in place, you will know, you would have probably done it many, many times, you know, where you were asked to produce a zillion of collateral warranties and your head just starts spinning because you just have so many parties here. So really, primarily, the funder, for example, will want to have control, to step into the project if it goes wrong. And so really, they definitely want to have that contractual control with the building contractor. That's the key one for the lender. So you will absolutely be asked to produce a collateral warranty that will state that the funder can step in and kind of take control of that same contract. So the builder cannot just walk away if the developer is not performing. They have to sort of stay in that relationship. And the collateral warranty will be done between these three parties. So the three parties to it will be the funder, the developer, and the building contractor, right? So which basically allow that contractual relationship between the funder and building contractor. Then also the funder or the developer, for that matter, will want some of the collateral warranties to be put in place with professional consultants. So really, you're really thinking, you know, who primarily sort of design element of it, you know, who are sort of the key responsible parties for the design. So generally, again, it will be your architect, structural engineer, these kind of professionals, you know, that have a real input in the scheme. So you will then need a collateral warranty, which will be between the funder, the building contractor and the professional, so the architect, for example. So you can see that, so that bit stays. So these parties need to be party to the collateral warranty, and whichever third party, whichever the beneficiary party is, let's say in this instance is the funder. The developer may also want to have one. Okay, so again, you've got this building contractor and architect, for example, here. So you may need another one, collateral warranty, for the benefit of the developer. So this will be between the building contractor, let's say architect, and the developer. So these are going to be your three parties. And that collateral warranty basically warrants to the developer that they will carry out everything they said they will carry out under this appointment. What subcontractors? Do you need all subcontractors? No. I mean, do you want like electricians, plumbers? No. Generally, you're only really talking about, as I said, some sort of like very, very either substantial financial subcontracts that the building contractor had undertaken, or the design element. Okay, so it will be pretty much, you know, some of these subcontractors you won't even know, but to be honest, they won't be relevant, because if something goes wrong, you know, can it be fixed easily, and who can be blamed for it? So it's key parties, really. Okay. Sometimes the funder will also ask that your building contractor or subcontractor or professional consultants provide a warranty to a future purchaser, a collateral warranty or tenant. Usually it states that they have the right to ask for one. They don't necessarily ask for one to be put in place right away. So if you're a building contractor, you know, you may be asked, for example, to do it in the future. But in reality, what happens is, as soon as that development is completed and the funds are returned, the bank is unlikely to want or ask for that collateral warranty to be put in place. But where a funder is, you know, providing the sort of product where you're actually retaining the development and are letting the development out, then it's a different story, because they still have the financial interest and may ask for this to be done. So as you can see, you know, it could be many different collateral warranties that may need to be put in place. Both if you're a developer, you can ask for these yourself so that you have these in place, and also your bank may ask for it at the point of lending. So coming to this slide now, at the top I've put sort of what collateral warranties sort of key terms are. In effect, they sort of firstly will repeat that pretty much the party that gives the collateral warranty, so whether it's the building contractor or the architect, they've taken proper skill and care in designing it, they've used appropriate materials, they've carried out works in a workmanlike manner, they maintain adequate level of insurance, and that basically they're going to perform everything they've set out to perform in that original contract. The sort of things that I wanted to point then in the blue section here is, so generally there'll be a few more clauses in the collateral warranty. One of them is step-in rights. So back here, so the funder, for example, here will be interested to step into the development and that contractual relationship. Let's take this triangle where the collateral warranty is given by the building contractor to the lender. So the lender will want to make sure that in the collateral warranty it said that should they step into the developer's shoes and come to deal with the development, that they can actually sort of step in and deal with this building contract. That collateral warranty will state that the lender can step into it and deal with this building contract with that builder. So basically the builder cannot just sort of like, so to speak, you know, just leave the contract and not deal with the lender. And so here I've also put that there will also usually be a requirement to give notice if that party wants to walk off or terminate the contract. So again, I'm going to go back to this example. So let's say the building contractor is not getting paid by the developer. The building contractor will have every right, you know, having asked for the payment, to walk off the site because the developer will by that time be in breach of its contract, JCT contract. They've got to pay the contractor. So let's say the builder wants to walk away from the site. The collateral warranty will generally state that this builder has to give notice to the lender here, alerting the lender that they're about to walk off or terminate the contract. And so that's your step-in right and the requirement to give notice, because then the lender will obviously want to safeguard its financial position and potentially, you know, step in. See, that's what the contractual warranty allows the funder to do. Generally, if the collateral warranty wasn't in place, the lender couldn't just simply step in and dictate to the builder what they ought to do. They could just walk away and not talk to the lender because they wouldn't have any obligation to talk to the lender. So that's what the collateral warranty will do. Also, the sort of things that collateral warranty will mention is that beneficiary, for example, the bank, has every right to use all the documents created, that they have the license, unfettered license, you know, they are not subject to requiring any consent or permission or payment, that they can use all the documents, in effect, therefore giving them full control. So these are quite key there. Now, moving to the next slide, the collateral warranty should never contain additional clauses trying to amend that original contract. So, for example, if I go back again, the building contract will already state the scope of works and what the builder is supposed to do. The collateral warranty here will only allow to sort of, as I mentioned, you know, to step in and get control of this contract, but it shouldn't contain anything additional. I had one instance where the collateral warranty said that the funder at that point of stepping in had the right to amend the building contract single-handedly. This cannot be done because the purpose of collateral warranty is to simply create this link. This link doesn't mean you can step into this appointment and change it. You know, it is the contractor, the builder, and the professional who'd already agreed what it is there to carry out. So, and that just simply connects you to that contractual relationship. It does not allow the red bit, the collateral warranty, it doesn't allow you to change the actual suddenly terms of what needs to be carried out per se. Okay, so therefore it should not contain additional clauses beyond that original contract. Usually the collateral warranty will last for either 6 or 12 years or anything in between. Generally, it is 12 years. It depends how it is executed. You may know that you may have heard if somebody breaches a contract, they can pursue a party within 6 years of the date of the breach, which is what is called a limitation period in sort of legal terms. If something is executed as a deed, which a lot of collateral warranties are, so when you go to the signature page, it says executed as a deed, etc., etc. And for deeds, you can pursue a party within 12 years of the breach, so it's a longer period. Generally, what happens is whomever gets the benefit of the collateral warranty wants that term to be as long as possible. So the funder will want it to be 12 years. The developer will want it to be 12 years. And whomever is giving that promise, you know, to carry out everything in accordance with the contract, whether it's an architect, you know, a structural engineer, building contractor, they will want it to be as short as possible, 6 years or so, because you don't want to be pursued after 6 years. But in practice, what happens is that most defects transpire within the first couple of years, really, unless they are sort of hidden or latent defects that can appear, you know, a lot later than in the first 2 years. But generally, that is the reason why it's, you know, a lot of the time it will be 12 years, which simply means somebody can pursue you really for 12 years following practical completion. So the next bullet point is usually it runs from practical completion. A lot of the time the collateral warranty will state that, so it will say it's 12 years from practical completion. So once the project is complete, any party that has the benefit of the collateral warranty can pursue the third party within 12 years from practical completion. If it doesn't state that it's from practical completion, then it will be from the date that it is signed, which again sort of generally sort of happens well either earlier or around practical completion. Another point I just wanted to make briefly is whomever is signing the collateral warranty, architect, structural engineer, building contractor, should just check their professional indemnity or contracts insurance to make sure they are allowed to give, that they would be covered, that their insurance would cover for collateral warranties and not only direct contracts. And so that can be done via a broker or directly with the insurer. And when should you enter into one? Well, really, as soon as the appointment is made, generally speaking. So really what you want to do is, at the very least, as you appoint that professional or subcontract someone, first of all, the best thing to do is make sure that that first contract states that this party, whomever it is, an architect, subcontractor, will be required at some point to provide these collateral warranties, and to which parties, so it doesn't come as a surprise. And ideally, it should also attach a draft of that collateral warranty to that appointment contract. Because what you'll find, let's say, for example, you've appointed, as a developer, you've appointed an architect to prepare some drawings for a planning application. And then, so you've entered into the contract of some sort here. And then further down the line, after you got your planning, you go and look for funding and asking for really tricky collateral warranties, and you have to go now back to the architect and say, can you please sign these? And then I'll end up having arguments as to whom it should be done, when, how, etc. So really, when you should enter into one as soon as possible, do not leave it to the last minute, because that's when the arguments sort of start. So now I've gone quickly to one of my sort of last slides, and really, terms of engagement, letters of appointment, I'm now talking about these appointments here, appointment here, or your subcontract. So when you enter into that relationship, again here, timing, enter at the point of engagement, what you might find is that at the point of, let's say, engaging architects at an early stage, here, I want to talk a little bit about this battle of forms. So again, I'm going to come back here. As you appoint your architects, actually what happens a lot of the times is a professional consultant that provide the developer with their terms. So they will have their sort of standard terms or terms and conditions. And of course, a lot of the time they will be drafted somewhat in that professional's favor. For example, they will have, the key sort of clauses that may be a little bit more favorable to that professional than the developer would want to be, is, for example, that there will be sort of limitation of liability clauses, which will really limit that professional's liability. Also, it may say that the copyright, that the developer only has a license but can't sub-license or transfer that license without that let's say, architect's consent, without paying their fee, these sort of clauses. And then, which you might find there's no problem when you start working with that architect, but what happens later, the lender sort of comes in and provides their draft collateral warranty, which actually says the opposite, that the architect has now to give this assurance that the lender, by way of collateral warranty, can have that license, but it's not limited in any way. And then, the limitation of liability clause will look very, very different. It will not limit that liability the way that it was limited initially. So what I tend to do myself is at that point, so when I talk to a professional consultant and then they send their terms to me, which I don't mind, because then these tend to sort of detail, exactly what that professional consultant is going to provide for me, or how much, etc. What I tend to do at that point is to actually then produce my own sort of draft terms, and I will lift, the actual sort of detail of the works to be carried out and prices into my own, in essence, contract, that letter of appointment, so to speak, and ask the architect or whomever that professional consultant is to sign it. And usually that draft already, I know my funders will be happy with. And also I tackle it from the beginning, I don't sort of wait for the lender to come at that later point, and then I have these different, terms that I need now to go and get someone to sign. Generally speaking, you know, whomever that professional is, they don't have a problem to sign these new terms and this collateral warranty, which is wider. But in any event, I tend to prepare my own. And by the way, I can share if anybody needs, you know, these sort of like letters of appointments. I mean, there is nothing untoward there. They're just more sort of like, they're the terms that are not as restricted as usually professional consultants will produce. And I know these are going to be acceptable to my funder. And so really then hopefully that consultant will sign them. And if they don't sign them, then you sometimes have, you know, what is called the battle of forms, and usually try and get those terms, you know, your terms before that professional starts working and performing. And then, you know, you're pretty certain then, even if they're not signed, that actually those terms will be the applicable terms. That's this bit. And really then I'm going to go to the next slide, which is my last slide. Oh, and level of insurance cover, sort of make sure that it's adequate as well, which kind of goes with my last slide. A couple of points I've put there. The insurance, as if you're a developer, as you're appointing these professionals and building contractors, you know, obtain those insurances, professional indemnity insurance, or all contractors insurance early on. Make sure the insurance cover is adequate, and have these insurances in place, because you'll have to provide these to your funder at the very least. Then another question is, do you need those collateral warranties when you have all of those 10-year build warranties? And the answer is yes. If I go back to my first slide. So as you complete the project, most of the time you'll have to get a 10-year or 12-year, whatever, build warranty. And generally speaking, the warranty is for these people. So you're only talking about this part of the diagram and relationship. So that warranty is really to protect the end purchaser or leaseholder. Whereas collateral warranty deals with pretty much all of this part. Also, sometimes the 10-year warranty will require that for the first 2 years, it is the building contractor that is responsible for that defect period. So that purchaser or tenant have the recourse, you know, for the first 2 years to go back to that building contractor who will have to deal with defects. Let's say that building contractor had gone bust, you know, you're quite likely having this contractual bit, the purchaser to come after you if you're a developer. And therefore, it's actually quite handy to have a collateral warranty here. Let's say if you need to pursue, let's say, an architect or structural engineer here. So that collateral warranty helps you where the building contractor is, let's say, insolvent, to go and have a chat with these professionals to see if they've done anything wrong and if they can help to rectify anything. So they're very different things, the 10-year building warranty and the collateral warranty. And that pretty much concludes my slides and my talk. So I'll probably either let Jonathan chip in, or happy to take any questions if anybody has any.
Thanks, Grazina. It's really, really nice and detailed. Some great information there. Really appreciate it.
Yeah,
open to any questions. Jonathan, do you want to?
Yeah, I can chip in a little bit. I entirely agree with everything that's been said so far in this presentation. I think what I can add is my experience of what happens where there are disputes in respect of collateral warranties, and it hits exactly upon one of the main points that Grazina mentioned as we went towards the end of that presentation, which is the timing of when the collateral warranties are signed. And really, I think what was being said was, in essence, you really want these to be signed before the respective party starts the work, if at all possible. Because the amount of times, the main issue that I have had with collateral warranties and enforcing collateral warranties in construction disputes for the 20 years that I've been doing construction disputes is You get to the end of the job and somebody wants to enforce a collateral warranty and it hasn't been signed. It has been included in the initial pack, but it possibly hasn't been part of the review process of the negotiations. So the other side will say, well, we didn't agree the terms of this. Or if there is a clause in the contract that requires them to sign it, you've got to go through hoops to potentially raise some sort of declarative action to require them to sign it if they refuse to sign it. So I do recognise, I mean, I've been a construction lawyer for a long time and I've worked in-house. I do realise that at the start of a project, a lot of the time people just want to get started, and once the construction contract is signed or the relevant main contract is signed, there's a urge and a temptation to go, right, well, that was the difficult bit, we'll sort out the collateral warranties later. 9 times out of 10, when you do that, later becomes when you need to rely on it and it's not signed. So it really is an important point. So yep, I appreciate that you want to move on in a project once you get started. I mean, there are plenty of projects that don't even start with the construction contract being signed. So that's another issue. But if you are in a the best time to get somebody to sign a collateral warranty is before you've started work and before there are any issues, basically, because you're negotiating a contract anyway. You might as well negotiate the collateral warranty. At the very least, get it confirmed that they've agreed the terms of it, even if they haven't signed it. That would be my advice. The other issue with collateral warranties sometimes comes down to the wording in them. But if you stick to Grazina's advice of making sure that it doesn't increase the obligations of that third party, then the wording should be, acceptable and enforceable. I see somebody said, can any forms be shared? I mean, I don't know, Grazina, if you have any standard forms. Yeah. I mean, I certainly would be able to share something, but the collateral warranty flows from the construction contract. So whilst there'll be standard forms, they will vary depending on what's in the construction contract. So that's the main points I would say is the annoying legal thing is get everything signed before you start work, even though you're under pressure to get started work. I know that, but that's the neatest way to make sure that everything's covered off.
Mm-hmm. Cool. Okay. Thanks, Jonathan. I see there's some questions and some comments coming in here. So I'm just going to start at the top. We've Emma Morby's asking about the forms. And Jay, you have a point to make, yeah?
I would just basically say that I've got 2 sites which were just about to sign JCTs on, and a collateral warranty was or amendments to the contract were thrown in at the last minute, and that basically pushed everything down the line. Solicitors had to get involved, and we missed our start on site date. On one of them, we missed the NHS funding timeline. And the other one, the lender actually just pulled out at the last minute. So it literally just screwed the whole project over. The lender pulling out wasn't much of a drama because the client's got another lender, but the NHS funding one was a big one. And that's because at the procurement stage, the client didn't add or advise to us as a consultants to add these documents in. We asked him at that time, and you know what, I'm getting to a point now where I just want to add in standard warranty documents and standard contract amendments, just to have something a peg in the sand, so that contractors can see that what they're going to sign up to before they even get to that final JCT signature, or that they know that there's going to be a raft of amendments, or there's going to be warranties that they have to do. So I'm just saying, probably reiterating what Jonathan was saying earlier, get it in at the procurement stage, get it in as early as you can to have those conversations.
Yeah.
Cool. Angelica, if the builder came out of business and architect, engineer have done nothing wrong, the insurance won't cover it. What is there to be done?
So if the builder goes bust, so am I presuming that the builder had done something wrong? So the first thing is you have to ascertain, the first point of contact would be to go back to the builder. If the builder goes bust, it's not necessarily true that you can't go to their insurance company. Some insurance companies, or a lot of insurance companies, and that's why it's important to get a copy of their insurance policy and schedule. You can go back. You can go to the insurance company, even though the builder had gone bust, and a lot of the time they will pay out. You'll still have to show the same thing, that that builder had done something wrong. You'll still have to prove that something had gone wrong as a result of their breaches. But you can contact the insurance company directly, even if the builder had gone bust.
How do you find out who the builder is? I'm talking from a point of view, somebody who purchased the property, and then the building is just, I mean, there's multitude of problems with it, and it's not very clear how to find out who to go after.
So generally, that's why you have that, warranty in place. So that warranty usually, kicks in. If it's in the first 2 years, that purchaser that has that contractual relationship with the developer, so they can go after the developer. Mm-hmm. If they're still about, and if that SPV is still there, and that is about it, really. Or the warranty depends on what year, when did the defects appear? Have they appeared right away? Is the NHBC or whatever warranty there is, does that cover them? If not, is the developer still around?
Yeah.
Because if they don't have the details of the builder, then they obviously can't pursue the builder.
Mm-hmm.
I mean, I can see the possibility. Say a contract has been built under deed. A property has been built under deed, so it's 12 years that you in theory have claims for, and then like 6 or 8 years in, you come in and you buy that property, and you have an entitlement, therefore, in theory, to claim for any defects that you might find, like latent defects. And possibly your question was aimed at, well, if you come in as a second purchaser rather than the first purchaser, how do you find out who the original contractor was? There's no register or anything whereby you can find details out, but as Grazina mentioned, if you can find the NHBC certificate or speak to the NHBC, if it's a property that has NHBC is relevant to NHBC regulations, they'll know who the contractor was.
Mm-hmm. Okay, thank you.
Okay. Jay Munoz, you've got a question. Jay?
Yeah, thanks. Thanks very much, Grazina. Very insightful presentation. One question, I don't know if I understood correctly, but you mentioned about collateral warranties between us, let's say, developers and subcontractors, not necessary. But for big projects, when subcontractors have big packages, would it not be a good idea to have it just to protect us, just in case? Because we as developers appointing a main contractor, they are only good as the subcontractors. So if they're subcontractors, obviously delay the project, that is a big issue for us. So would you recommend for big packages, for big subcontractors, to have a sort of a collateral guarantee as well, or we just what is the best way to proceed in there?
Yeah, I think if it's a really important big package, yes. For example, I've got like a large, sort of like Windows package, etc. But in general, for as long as your builder is solvent, mm-hmm. It is the builder's primary. You can still pursue the builder for something that subcontractor had done wrong, or if they're late. Okay, so you don't have to go after each and every single party. So if you appoint the builder to undertake the works and then they subcontract, they are responsible for those subcontractors' actions, okay? Mm-hmm. So your primary recourse is still to go to that builder under that main JCT contract. And then what the builder generally will do is they will bring in that subcontractor sort of behind them and say, you know, what have you done? And, you know, they try and resolve that dispute. But if you do have a collateral warranty as well, it gives you that opportunity to go either additionally to pursue that subcontractor if something goes wrong, or where your main contractor no longer exists, you know, go straight to that subcontractor, which might be your only option at that point.
Okay, yeah.
But you don't want to go crazy, you know, you don't necessarily want
with every single one, yeah.
Yes, because
Yeah,
you
well,
know, you'll have a
packages,
zillion
right?
of stuff. It's something that is, you know, like a big part of the contract, something that can go wrong, design element of it. That's what you need to sort of worry about.
Well, I guess also make sure that the subcontractor has got collateral as well, because as you pointed it out, if he hasn't got collateral, then you're not able to claim anything as a developer, right?
That's right.
Cool. Thank you for that.
Jonathan, you wanted to add something?
Yeah, I was just going to say, and obviously the more collateral warranties, or the more stringent collateral warranty you have, the more that a subcontractor might add to its price for risk. So yeah, it's a balancing act. You know, you want to protect yourself, but equally you don't want to overspend. And I see Tina's made a good point. From a consultant's perspective, collateral warranties need to be reviewed by their insurers, and if they're asked retrospectively, they're likely not to be taken up because they weren't factored into the original fee proposal relative to risks. And that comes back to Jay's, the first question we had from Jay, which is really if you get your collateral warranties in draft as a schedule to your construction contract as a rule, so that they're there, you don't have to think about it every time you produce a construction contract, or you know, if you're a contractor or a project manager, if you've got as schedule or appendix 2, 3, or 4, whatever, a collateral warranty, it's there as part of the contract to be reviewed and agreed.
Good. Thanks for that, guys.
Thanks, Jay. I am mindful of time. I know some people might need to head off and collect children or go to other meetings or the like. So I'm going to say a very, very big thank you to both Grazina and Jonathan for your time. Really appreciate it. We do have some more time if anybody would like to stay on. Obviously, if there's more questions to be asked, please feel free. But if you do need to log off, now is your chance. Thanks very much.
All right, thank you.
Thanks, everyone. Cheers, Grazina.
Who we got staying on?
I'm surprised anyone usually stays on. It's like a working day.
Sometimes we get a few.
Linda wants to ask a question. She's staying on. Come on, Linda.
Are you mute, Linda?
Yeah, I'm on mute. Yeah, well, thank you. That's really interesting. I'm actually working on something at the moment where it's like a design and a build contract. And it seemed like the developer is, they don't really know how to do this. So like whose responsibility is it to make sure that all the contracts are like signed? Is it the developer or is it me as a subcontractor?
Yeah, the developer really is the one that usually facilitates the contracts package.
Yeah.
As you're a consultant, usually you are going to be asked to provide a collateral warranty as a consultant, you know, and somebody needs to ask you to provide one. But for your own terms, you know, if the developer is not doing anything, you provide your own terms. Just put whatever your terms need to put, you know, I'm sure you have a set of terms, and then if the developer needs to do anything different, they should come to you.
Yeah, okay. Yeah, and also it's interesting, like Tina said, it might not be included in the initial fee proposal, so that might have to change. But do you have any advice on how to work on this, because sometimes I feel like developers are not really aware of the process and are asking you a bit, what do you say, unreasonable questions at that early stage.
What sort of things are they asking? I mean, it just sounds like they're not very experienced. Is that right?
About costing and these kind of things. And from my perspective, I can't really establish a price unless the design work has been done.
Mm-hmm.
When that is ready, yeah, I can cost it. But if it's not, it's like, okay, can you give me a fee for a website? Yeah, well, what kind of website is it that you want? Or yeah, how it's gonna look like? So yeah, so the process is not always very clear.
Yes, that is quite tricky because a lot of developers don't have a good architectural package.
Yeah.
Linda does interior design, so do you tend to sort of work on the layouts as well, or do you just do interior?
The layouts as well. I normally, when I work with developers, that is coming in early and change the layouts around and electrics and all of that. So yeah. But it's a bit confusing when they are, I mean, I'm starting to do the fit outs as well, but when things are not really clear from the developer's perspective. So
yeah.
I mean, the main thing is not to start, committing yourself to work until you're sure about what the scope is. As soon as you start working and you don't have a clear, I mean, you really should have a contract. I know it's boring lawyer stuff. You really should have terms and conditions. I agree with Grazina. If they want you to get started quickly and they aren't putting a contract to you, then you put your own terms to them. And if they don't reply and you start working, the legal position, it's not ideal, but the legal position is that you've put your terms to them. They haven't rejected them. You're working to them. As soon as they accept your work, they have accepted by conduct your terms and conditions. So it's not an ideal position, but it's way better in theory having your terms and conditions applying to a contract than having somebody else's. Also, from a collateral warranty perspective, it's unlikely that interior designers would be asked for a collateral warranty, but if you haven't been asked for one, good. You don't want to have extra burdens on you. So it's very much a top-down benefit rather than a bottom-up benefit. You don't want to sign a collateral warranty. So if these guys, let's say they wanted you to sign one, but they didn't get their act together, then that's a bonus for you. So you don't need to worry about that. They need to worry about that. And if they screw up on that front, then that's their lookout. That said, if you want to get started on the job, well, you do need a scope. But if you can get your terms agreed rather than their terms, then you can push it forward on that basis.
Yeah, well, definitely. Thank you. Yeah, that's kind of what I have done as well. So I haven't started. So.
Yeah. You can include things, what you'll provide and what for, and then anything extra is based on an hourly basis, extra scope of work, to be agreed, how you're proposing to charge for it. You can append to your contract, you can append what you've had so far and that you've based, your pricing and what you're going to do on the basis of the plans that you'd received so far, so that it allows you then, if something changes, which they probably will, like they will finally prepare some sort of architectural package, then it's extra time of yours that you're going to spend reviewing them and redoing them. And so your contract should really state that any further extra work will be at X hourly rate or something like that, and that at least will give you the opportunity to say you should be charging more at that point,
Absolutely. So if you've been given some scope, but not all of the scope, and are being put under pressure to get started, you should know the scope that you've been given in writing, and note that you're aware that there's further scope still to be added, and that you're starting on the basis that the attached terms and conditions apply, i.e. your terms, and this initial scope of work that you know about is going to cost £15,000. But unless and until you get to the end of that scope, unless they give you further scope, it'll either be, as Grazina said, done on an hourly basis, or you'll stop working and wait until they give you, the new scope. So that's kind of loosely known as a letter of intent. It's not something that I would advise, but it's better than having nothing in writing.
If the worst comes to worst, just make sure you put everything in emails anyway. At least, even if there is that email correspondence and there's no proper terms from either party, that's even less ideal, but it's still something that, that can be looked at, whatever you agree in that email correspondence between you.
Exactly. Specifically your price. As long as you get your price in, the law will fill in the blanks if there are any. But as long as you get your price in and what you're doing for it, then you're covered.
Okay, thank you.
Yeah.
Cool. Hi Becky, you all good?
Yeah, I'm good, thank you. I've got no questions, but it's really interesting today. Thank you.
Good.
Jay, I know Jay logged off but logged back on his mobile. I don't know if he has a final question or anything to say. Might be driving or something.
Yeah, he might just have forgotten to log off.
Yeah.
It's a school run if you've got to pick up your kids, I guess.
Yeah. Thanks, guys. That was really, really nice. Really appreciate the time. I think that was very, very informative.
Okay, good. For as long as people didn't find it boring, because as soon as you mention, there's something legal there, people go like, oh God.
No, I think that probably is very close to, or might even break the record for the most attended Q1 Live. So people definitely didn't find it boring.
People prefer hearing about legal things from people who are no longer lawyers, I think.
Yeah.
True.
Yeah.
A sheep in wolf's clothing.
Yeah.
True.
Grazina, are you okay for us to share that slide deck? Yeah.
Sure. Yeah, absolutely. Yeah. I've sent Rekha the up-to-date one today.
Yeah, I have that. So I will add that to the follow-up email.
Yeah.
And then with regard to contracts, you said people could have. Do you want me to just email you that?
Yeah, I have a good I have like a good letter of appointments, as I call it, that sort of like when I appoint professionals, which is quite good and applicable, then obviously people have to look into it, but that's the general one I use. And then, the collateral warranty as well. Again, I mean, usually, sort of like, to be honest, usually it's the lender that dictates what the collateral warranty looks like. But at the point before the lender comes in, they might want to have some sort of, like contract plus appended collateral warranty, which I can share. Yeah, definitely.
Okay.
Nice.
That'll be good.
All right. Cool.
I'll get in touch with you about that as well, Grazina, because there's a law site that I'm a member of that creates blank documents, so you wouldn't have to worry about blanking out names and stuff like that.
Okay.
So maybe I can email you.
Yeah.
Just for you to look at and just see if it's the sort of thing that.
Yeah, that'd be great. Yeah, sure. Let's do that.
Okay, cool.
Okay.
Awesome.
Thanks,
everyone.
guys.
Thanks for joining us.
Thank you. It was not boring at all. I think this is very important. So it's
excellent.
Super helpful. Thank you.
Yeah.
All right. Thanks, guys.
Bye.
Bye.